Good afternoon, everyone. Thank you for joining us today. My name's Sue Apps. I'm a partner in Ashford's employment team, and I'm joined today by Hayley Marles, Senior Associate in the team. Quick housekeeping before we dive in. We will have an opportunity for questions at the end, so feel free to enter any that you have into the Q&A section at the top of your screen, and we'll answer as many as we've got time for at the end. After the webinar, we'll be sending out the recording and slides, so you will get a copy. So today we're looking at some of the most significant changes to unfair dismissal law that employers have seen for many years. Introduced by the Employment Rights Act 2025, as you know, and due to take effect primarily from January 27. So taken together, these reforms have the potential to change not only the legal risks associated with dismissal, but also the way employers approach recruitment, probation, performance management, and of course, workforce planning. Over the course of today's session, we're going to be looking at three key changes. Firstly, the reduction in the qualifying period for unfair dismissal from 2 years down to 6 months. Then we'll look at the removal of the current statutory cap on unfair dismissal compensation and the extension of tribunal time limits from 3 months to 6 months. Hayley's going to be taking you through the changes to compensation and time limits and what those are likely to mean from a claims and litigation perspective. I'm going to focus first on what I think will be the change most employers are going to feel on a day-to-day basis, that being the reduction in the qualifying period for unfair dismissal from 2 years to 6 months. Now, whilst the other reforms, they're undoubtedly important, this is the change that's likely to affect management's decision-making almost immediately. As you'll be aware, for many years, employers have become used to operating an environment where, if we put discrimination, whistleblowing, other day one rights to one side, employees generally needed 2 years' service before they could bring an ordinary unfair dismissal claim. And that 2-year qualifying period has shaped workplace practice in all sorts of ways. So it's influenced how employers think about probation periods. It's influenced how quickly concerns are addressed in the workplace. And it's also often provided a degree of flexibility when it becomes apparent that an employment relationship is just not working out. From next January, that landscape changes significantly. The reduction from 2 years to 6 months service for unfair dismissal protection is going to require quite a significant shift in mindset. So now the questions that employers are going to increasingly need to answer are ones like, how quickly can we identify concerns? How do we use probation effectively? When do we need to make decisions? And how do we avoid finding ourselves having to run a full unfair dismissal process only a few months after somebody starts work? And those are the issues I'm going to be focusing on today. So the first consequence of this change, it actually arises before somebody joins the organisation. It's going to start with recruitment, because if employees gain ordinary unfair dismissal protection after 6 months rather than 2 years, there's a greater premium on getting recruitment decisions right in the first place. Historically, some employers have been comfortable taking a degree of risk at recruitment stage. So the thinking is often, well, they seem promising, they interviewed well, let's give them an opportunity and see how they develop. There's nothing inherently wrong with that position, with that approach, but the cost of a poor recruitment decision is potentially increasing now. So for many organisations, that's going to mean looking again at the recruitment model itself and asking whether selection processes are sufficiently robust. So are we genuinely clear about what the role involves? Are we recruiting at the right level? Crucially, are we testing the things that actually matter in the role? Or are we relying too heavily on a good interview and a positive impression? So in particular, organisations should be thinking more critically about how they assess capability and behaviour during recruitment. A candidate might interview well, but have we actually tested whether they can do the job? So how do we do this? Well, for some roles, that may mean practical assessments, presentations, written exercises, or work simulations. For others, it might simply mean more structured competency-based interviewing. But the important point is that the closer we can get recruitment assessments to the reality of the role, the better the quality of decision-making is likely to be. And I also think employers are going to need to become a little less reliant on potential alone. Potential, of course, remains important. But where recruitment decisions are based primarily on what somebody might become in the future, rather than what they can demonstrate today, the risks inevitably increase when we've got less time for them to show that potential. Another question for organisations is whether recruiting managers have been given the tools to make good recruitment decisions. We see that many managers are excellent at managing operational teams, but they've never received any meaningful training on interviewing, assessing capability, or identifying risk indicators during recruitment. So this could be a good opportunity to step back and review whether additional training is needed in that area. So some organisations might even conclude that certain recruitment exercises should be outsourced or supported by specialist providers, particularly where they are recruiting into critical or hard to fill roles. The other area that's worth reviewing is relationships with any recruitment agencies. If they're playing a significant role in sourcing or screening candidates, are expectations clear? Are agencies assessing the characteristics and skills that genuinely matter for the role? And are references and pre-employment checks being obtained quickly enough to support that good decision making? Because under the new regime, every part of this recruitment process is going to become more important. The better the recruitment decision, the less likely you are to be dealing with performance concerns and dismissal decisions 6 months later. Okay, so we've gone through recruitment, someone's joined the organisation, that brings us to the probationary period. Now, probation is no longer simply an onboarding tool. Historically, many organisations have viewed probation as a settling in period, a chance for somebody to learn the role, build relationships, understand systems and processes. And all of those things, of course, remain important. But now probation is going to perform a much more significant function. It becomes the employer's primary opportunity to assess whether the individual is right for the role before unfair dismissal protection arrives. So in effect, probation starts doing some very heavy legal work. One point is that employers need to understand exactly when the window closes. And this is where things become slightly confusing, because that assessment period is actually shorter than many employers realise. Many will look at the new legislation in the same way as with our existing legislation and think they have 6 months, or currently 2 years, to make a decision. And in reality, that's not quite right. Some of you may already be familiar with the rules around statutory notice and qualifying service, although it hasn't had the same level of importance up until now. So for unfair dismissal purposes, statutory minimum notice is added when calculating eligibility. So for someone with less than 2 years service, that's typically 1 week, the statutory minimum notice period. Where notice is not worked, that week has to be added to the termination date when calculating whether they have unfair dismissal protection. So the practical consequence of that is that the decision point often arrives at around 5 months and 3 weeks rather than 6 months. So I'm just going to talk through a quick example. So let's say you've got an employee who starts on the 1st of February 2027. They're going to reach 6 months service on 31st of July. Now, concerns arise during probation, but we're hoping for improvement, so the manager waits. further concerns arise. Eventually, we decide to dismiss on the 25th of July, and we're going to terminate employment and make a payment in lieu of notice. So the termination date, for all purposes, will be the 25th of July. So many employers would naturally assume they remain safely within the 6-month period. But for the purposes of calculating unfair dismissal protection, we need to add that statutory notice period on, and that takes the effective date of termination purely for that purpose to the 1st of August, meaning that they've achieved the 6-month service required to bring an unfair dismissal claim. This isn't a new rule, but it was less likely to be an issue when we had 2 years to consider dismissal. We're less likely to leave it till the last few weeks or days. But I suspect we're going to see quite a few employers caught out by this during the first few years of the new regime. And that timing issue has an important consequence, because 6-month probation periods may no longer be the safest or even a safe model. If probation ends at 6 months and there's a dismissal at that point, unfair dismissal qualification will be achieved and a full dismissal process would need to be followed. So in practice, many employers are going to be better served by a 3 or 4 month probation period with a clear contractual right to extend it. I would say to 5 months, at the absolute longest 5.5 months. We're going to need structured review points throughout and a clear decision before the 6-month threshold becomes an issue. So before that added on week brings you to 6 months. The key message is probation can no longer be passive. It needs to be structured, needs to be deliberate and properly managed. So another reason probation becomes more important, it's not just about deciding whether someone stays, it's also about creating evidence if concerns continue after probation. And I think that's a point that is frequently overlooked. So let's imagine 2 organisations facing exactly the same performance problem 8 months into employment. In the first organisation, managers conducted regular probation reviews. Expectations were clearly explained, concerns were raised when they arose, support is offered, progress is monitored, and we've got a clear audit trail showing what conversations took place and when. Now, they passed the probation period, but with those concerns recorded. Performance remains problematic at 8 months. The employer here is not starting from scratch. That probation period becomes the beginning of the performance management story. It provides context, it demonstrates consistency, and it helps to show that concerns were raised at the time rather than retrospectively. Now compare that with a second organisation where probation meetings are missed, feedback's vague, managers are avoiding difficult conversations because they don't want to demotivate the employee. The employee passes probation with no obvious concerns recorded. Then at month 8, performance becomes a serious issue, and that employee is going to face a much more difficult challenge, because the obvious question becomes, if performance was genuinely a concern, where's the evidence? Why was nothing raised during probation? Why was probation successfully completed without those concerns being recorded? So good probation processes are not simply about managing the first 6 months and that unfair dismissal risk at that time. They can become absolutely critical evidence later on. So what mistakes should employers be looking out for? Well, the first is delayed decision making. Managers are often optimistic. They hope things will improve. Sometimes they do, sometimes they don't. 3 months, which is often the start of a probation period, it does often feel a very short time for an employee to settle in and learn the ropes. But we've got to be really proactive during that time. One of the most common phrases we hear is, let's give it another month. And occasionally that's absolutely the right decision. But there needs to be evidence supporting that decision rather than optimism alone. Second mistake we see is avoiding difficult conversations. So many managers worry about damaging confidence or upsetting a new employee. And as a result, feedback becomes diluted. Concerns become hints rather than clear messages. And then, of course, formal action comes as a surprise. So in my experience, employees generally cope much better with honest feedback than employers often imagine. Third mistake is treating probation reviews as an administrative process. Probation should not consist of a form being sent out a week before the end date. It should involve ongoing conversations throughout the employee's first few months. And the fourth mistake is failing to equip managers properly. So most successful probation management happens through line managers rather than HR. If managers don't understand the process or the timelines or their responsibilities, that's where problems are likely to arise very quickly. So what does good practice look like? Well, I would suggest 5 key principles: clarity, regular reviews, early intervention, documentation, and timely decisions. And these are not particularly revolutionary ideas. But what is changing is the importance of getting them right. So the real question for employers is how those principles are translated into day-to-day processes. So before I pass over to Hayley, it's worth just thinking through what organisations should actually be doing over the next 5 months to prepare for these changes. While January 27 may still feel some way off, the reality is that employers will need to start preparing well before then. And the first thing I would recommend is reviewing your probation arrangements. If you currently operate a 6-month probation period, ask whether that's still going to work under the new regime. As we've discussed, the practical decision point may be closer to 5 months and 3 weeks, so we need to push everything back a bit. And even then, that's going to leave very little room for slippage, extensions, or indecision. So, as we mentioned earlier, you might want to consider whether a shorter probationary period combined with a clear right to extend would provide greater flexibility. Second area to look at is your employment contracts. Do your template contracts contain a clear and effective probation extension clause? So just for clarity, I'm not suggesting you need to be looking at your existing employees' contracts because their probation is irrelevant for them right now. Anyone that you recruit nearer to the end of the year where they're not going to automatically have 6 months, that's who we need to be looking at, and all future recruits. So if your contracts don't include that clear and effective probationary clause and the right to extend, now's the time to review them. Because without that flexibility, employers are going to find themselves having to make difficult decisions before you feel that you've gathered enough information to do so. Thirdly, let's review your probation processes themselves. So for many organisations, probation has historically been quite light touch, a meeting at the start, a meeting at the end, perhaps one form to complete, and that approach is going to become increasingly difficult to justify. So instead, employers should be thinking about formal review points throughout the probation period, documented outcomes following each discussion, and clearer expectations from the outset about what successful performance actually looks like. And that links directly to job descriptions as well. If the organisation can't clearly explain what the role requires, it becomes much harder to assess performance objectively during probation. And the fourth point is to ensure there is a formal probation outcome. One of the things we often see is probation simply drifting to an end without any clear decision being recorded. And going forward, employers need to be documenting whether probation has been passed, extended or failed, and recording those decisions promptly. Finally, don't forget that managers need support. The quality of probation management, as I've mentioned, will often depend on line managers rather than HR. So it's so important that these managers understand the process, understand timelines, and understand the importance of appropriate documentation. And you might want to put some training in place prior to January. Also worth reminding managers that emails, Teams or Slack messages, notes and other communications may ultimately be disclosable in litigation or in response to a subject access request. That doesn't mean managers should avoid documenting concerns, quite the opposite, but it does mean they should document them professionally, objectively and appropriately. And I think where people often get caught is in this more informal means of communication like Slack messages and Teams. That's where we often see the problems in DSARs. But the good news is that none of these changes require organisations to reinvent their HR processes. Most employers already have these building blocks in place, and the challenge is going to be making those processes more structured, more consistent, and more proactive than they may have been historically, and getting on board all of your managers to lead by this example. So if I were to leave you with 3 practical messages today, they would be these. First, probation is no longer just an onboarding process. It's becoming one of the most important risk management tools that employers have. Secondly, the real deadline is not 6 months. In practice, you need to be thinking and acting well before that point. And thirdly, successful organisations are likely to be the ones that equip managers to have honest conversations early and to make those decisions confidently. The new legislation doesn't make a dismissal impossible, and I don't want anyone to leave here thinking that. You will still be able to address performance and conduct concerns where necessary. It just requires that shift in approach, earlier conversations, earlier decisions made, better documentation, and more active management during those first few months of employment. And it's the organisations that adapt to that change and that whole cultural shift that are likely to find the risks remain manageable. Those that continue to treat probation as a passive administrative process may find the landscape looks very different from January onwards. So that brings that section to a close. I'm going to pass over to Hayley to take us through the other 2 major changes that we've got to unfair dismissal law.
Good afternoon. Thank you, Sue. The reduction in the requirement for continuous service, as we've heard from Sue, from 2 years to 6 months is a significant change. There's been far less said generally about the next one that I'm going to talk to you about, but it's still a major change and one that employers really do need to be aware of, particularly when factoring risk, exposure and headline costs when looking at making dismissals. That is the removal of the unfair dismissal compensation cap. Historically, an unfair dismissal claim has been seen as a fairly contained risk. Compensation was capped at the lower of a year's pay, or just over 120,000. Currently, employers can broadly quantify their worst case exposure in a claim of ordinary unfair dismissal. And when advising clients, we can provide a reliable assessment in most cases of a maximum risk in terms of a claim valuation. It's either a year's pay, or as it stands now, £123,453, whichever is the lower. But that ceiling is going, and this changes behaviour. Higher paid and senior employees now have a real financial incentive to bring ordinary unfair dismissal claims. Some organisations may not think this is a big issue if most workers are paid national minimum wage or thereabouts. But again, behaviours may change, expectations change. If an employee understands the cap has been lifted, their appetite for that higher ticket value may grow, and settlement discussions from the employer's side may be more difficult to progress with them, particularly where they are unrepresented. Their expectations may change. Losses can include salary from the date that the dismissal takes effect, up to the time that the employee finds new employment at the same or a similar level. Or you might see significant claims now for losses up to a planned retirement date. Losses can also include bonuses, incentives, overtime, commission, shift allowances. The employee can also claim loss of benefits, including their private medical insurance, company car allowance, life assurance, income protection, share schemes, and other contractual benefits, pension contributions too. You get the gist. This is all added to the potential value of the claim. Whereas before, there was a limit to what could be claimed and businesses could forecast the maximum potential loss when faced with a claim. When the cap goes, we're likely to see expectations rise and employees claiming for long periods of loss while claims sit in an already congested tribunal system. Amy, would you mind changing the slide, please? Thank you. So here we have an example. We have a head of sales, a very good remuneration package here, dismissed from their employment having gained 2 years service as we're pre-January 27. The head of sales considers the dismissal was unfair and she's going to bring an unfair dismissal claim. Instead of a maximum claim value at the cap of £123,543, the business could be looking at a claim in the region of £301,500, a significant difference. This is on the basis that the employee thinks that she'll be out of work for 18 months post-dismissal. We may not agree with that, but at the outset of the claim, this could be the employee's expectation, and the lifting of the cap allows that. With the cap being removed, we could see a greater appetite to bring claims because the potential loss is much greater. And it may mean that it is much harder for us to get started with negotiations because the gap between the employee expectation and perhaps our employer budget or appetite is growing. Next slide, please, Amy. The head of sales, as we've seen, is looking for just over £301,000. It doesn't mean they'll be successful at that level. Let's say the claim is brought, it is successful, it's not what we want. A tribunal can apply reductions to a compensatory award where an employee is successful. And often, depending on what's happened leading up to the dismissal, the principles of these reductions are used during negotiations to try and drive the figure down. Employees that are pursuing a claim are under a duty to keep their losses to a minimum. That means looking for work and providing evidence of that to demonstrate that despite their best efforts, they haven't been able to source an income and are really entitled to that sizable loss of earnings. Going back to our head of sales example, 18 months is a really long time for somebody to be out of work and completely without income. Without evidence of mitigation or medical evidence to show that they couldn't work in any capacity, they may have difficulty persuading the tribunal that the company should be coughing up for the duration of that period. Why should they? In practice, if on the other side the company can show that the employee could have found work within a 6-month period, a much more reasonable period despite seniority and the high salary, the award could be reduced to reflect a period of, 6 months loss of earnings. If our head of sales have been caught sharing sensitive information with a competitor and later found themselves to have been dismissed, the employer may well say that their conduct contributed to their employment ending. And in that situation, they shouldn't be entitled to the level of compensation that they're after. A reduction can be applied in these situations, known as contributory fault. And if as an employer we haven't perhaps done the best job when it comes to the process that we followed leading up to the dismissal, but it's clear that the outcome would have been the same despite the flaws in the process, we could argue that the employee should face a reduction to the amount of their compensation, the logic being that the flaws in the process don't matter so much because the end result would have actually been the same. If that's the case, it's not right or just and equitable for the individual to receive such a high award. A reduction can be made in this situation, and we commonly see this and use this as a means of driving down the claim valuation, typically in a redundancy situation. This is known as a Polke reduction. If the employee does not adhere to the ACAS code of practice, they could see a reduction to their compensation level of up to 25%. Examples of an employee failing to adhere to the code can include things like failing to attend a grievance or disciplinary meeting without good reason, or failing to appeal a disciplinary sanction or dismissal. But these reductions apply only after an award is made in a situation where the employee is successful at tribunal. We obviously want to ensure that claims are successfully defended. So why are we telling you about the potential reductions? Well, because they are factors that we as advisors consider when valuing a claim and negotiating settlement, but also at the early stages of supporting our clients where there may be a dismissal looming. So these considerations do factor into what may constitute a reasonable outcome. So I suppose there's a little bit of reassurance there in the sense that whilst the cap is being lifted, and that does seem quite frightful given the potential levels of compensation, there are areas where we can successfully negotiate to drive those levels down if the chances permit. Next slide, please, Amy. Thank you. As a result of the cap going, procedural fairness becomes critical, even where the employer feels confident that the outcome was justified. So an example of where this may really cause an issue, going back to our head of sales or sales team, as we have seen, or at a senior level higher. You have a senior salesperson on big commission schemes who underperforms. Let's say they're on a salary of 100,000 and they're getting bonuses of around the same level, 100,000. In our experience, many employers will want to move quite quickly on exits here due to the business risk. We're not saying that you can't still move fast, but the process is going to be so much more important now, because if the dismissal is unfair due to an insufficient process and the employee can show that they've been unable to gain new employment at the same level or a similar level for, say, 18 months or so, then theoretically, they may have a claim for £300,000 or more. There are arguments, as we've discussed, that can be run around the level of loss, reductions, as mentioned before, and particularly if you can prove underperformance, but you get the benefit of the increased risks here. Procedural fairness is critical. This is often the area where we find that employers struggle, actually. If you're dealing with a process that could end in dismissal and you miss a step, which is a breach of the ACAS code of practice, this will enable the employee to point to this and claim an uplift to the compensatory award up to a maximum of 25%. If the compensatory award cap is removed, the 25% ACAS uplift becomes much more significant. Going back to our head of sales example, if we as the employer received allegations of misconduct, but didn't, for instance, pass them all on or perhaps give as much information to that employee during the process as we could have done, this may put us in breach of the ACAS code of practice and could enable the employee to claim an uplift. If given 25%, we could be looking at a potential uplift of around £75,000. This added to the claim value of £301,000 is staggering. So not providing the employee with all of the relevant evidence, abiding by the ACAS code, not abiding by the ACAS code, for instance, denying the right to be accompanied, are further examples of breaches of the code, which would allow an uplift. Next slide, please, Amy. Finally, time limits. The time limit for bringing unfair dismissal claims will increase from 3 months to 6 months from October. So this means that claims for unfair dismissal, discrimination, whistleblowing detriment claims, victimisation and other statutory claims will have a longer window. With ACAS early conciliation running for up to 12 weeks since the end of last year, employers may now not see claims until many months after the dismissal or the incident that occurred and relied upon in the claims. There'll be some of you that have been on the receiving end of a claim without the ability to have any sensible conversations via ACAS or even an attempt at conciliation. And some of our clients report feeling shortchanged because that would have given them the opportunity to resolve the dispute at that level. So you've not been given adequate notice or chance to resolve the issues. And this can happen if the employee doesn't want to engage. And as it stands currently with the tribunal system under strain, these claims can come in months down the line. There is scope for these time periods to get longer, where employees have double the time now to get a claim in. And it is predicted that this change in particular will likely mean more claims. Next slide, please, Amy. So what are the impact on employers as we see it with this change? Well, as I say, there is likely to be an increased risk of claims. more employees are likely to bring claims because they've got longer to decide whether they want to litigate or not and what they want to do. Cases that previously would have become time barred by that 3-month rule may now proceed. Workplace disputes remain live for longer, so employers will have to manage potential litigation risk for a longer period after dismissal, disciplinary action, or other workplace events. An employer will no longer be able to assume that a dismissal is unlikely to be challenged after 3 months. There'll be a much longer period during which claims may be issued. Annual settlement strategy may change too, so claims may land after key personnel have left, for instance. And if that key person that's gone from the business was your decision maker in the dismissal process, this could damage the chances of you being successful with the defence to the claim. So this could change your overall strategy. Greater emphasis on record keeping is going to be needed. So document retention is going to become even more important now. HR records, investigation notes, emails, disciplinary and grievance documentation will need to be retained and easily accessible for longer periods because claims may emerge several months later. A 6-month delay or so before a claim is lodged means witnesses may struggle to recall conversation and events accurately. So making sure that you've got those contemporaneous records early on and front loading the record keeping there is going to be even more valuable now. But there is an upside. Longer timeframes can create more opportunity to resolve issues internally before positions harden. So depending on the circumstances, you may have, for instance, an appeal process which may take weeks to resolve. Your employee perhaps is unwell during that process and struggling with a mental impairment or a condition which causes delays to the process. There might be a situation where you have operational challenge for the appeal officer, meaning their focus is not on the appeal. In some cases, where acting for employees, they can be really up against that 3-month deadline because for whatever reason, that internal process is dragging and they need to get a claim in to safeguard their position. May not be a very good claim at that stage, but it may just be a case of them wanting to safeguard the position and support themselves so that they don't find themselves outside of that limitation period. Having a 6-month time frame will hopefully stop these claims coming through and allow employers a good opportunity to deal with those internal processes. Next slide, please, Amy. So there are 3 key takeaways here that I just want to talk about very quickly. If we were to boil all of this down to 3 practical takeaways for HR teams, they would be these. First, as Sue has already mentioned, probation is key. Review probation policies now. From the 1st of January, anybody with 6 months service at that point will have protection. So it's your new recruits from this summer onwards that need new processes. Secondly, early performance conversations are cheaper than late legal ones. And third, processes are going to be even more important than ever. The changes introduced by the Employment Rights Act do not make dismissal impossible, but they do mean that employers need to be clearer, braver, and act earlier. And HR sits right at the centre of making that work.
Thanks, Hayley. That's great. We've got just a couple of minutes left for some questions. We've had 2 questions, both essentially the same. And I think in the last 1 minute of our presentation, Hayley has probably answered that, but I'm going to reiterate it because it's a super important point. The question was whether the changes from the 2 years to 6 months applies retrospectively. The answer is a resounding yes, and that's super important. So when the new rule starts on the 1st of January, any existing employee who already has at least 6 months of continuous service at that time will gain unfair dismissal protection straight away. They don't have to wait 2 years, their past service will count. In practical terms, that means that anyone recruited on or before 1st of July is going to have 6 months of service and unfair dismissal qualifying period at the 1st of January. So they'll get it from day one. Hired after the 1st of July, then they will qualify once they reach their own personal 6-month work milestone. So I hope that makes sense. That's a really, really important point. So thanks to those who raised it. Got no more questions. I hope you've all found that helpful and ready. I'm sure a lot of people I know are already looking at this and really taking time to look at their probationary periods and processes now. If you haven't started, please do get started. If you need any help, you know where we are. But thank you for joining today.